has become a tool for every kind of greed. Instead of preventing crime, the law itself is guilty of the abuses it is supposed to punish. If this is true, it is a serious matter, and the moral duty requires me to call the attention of my fellow citizen to it. Frederick Bastiat in the law. So Dele Farotimi's acknowledgement. This book is to his wife. For Olufunmilayo, the one who constantly gives me peace, love, and happiness. Thanks for everything. So the foreword in this book goes thus. This is not a biography, for I have painstakingly provided glimpses of my early life in an earlier sequel to my first book. My purpose here is to tell you the story of my sojourn within the Nigerian legal system and to show you how our justice system, the Nigerian justice system, is in itself criminal, lending credence to how the criminality of the judiciary is completely reflective of the Nigerian state in its full ramifications and with full evidence of how this rot, having become systemic, is insidious and reaches to the very top of the judicial system. I will tell you the story of the complete and total loss of the capacity to deliver justice against the backdrop of a case that was decided by the Supreme Court and which records are in the public domain. I speak specifically of the case of Major Muritala Gbadamoshi and HRH, His Royal Highness Oba Tijani Akinloye, and ORS, otherwise known as the Gbadamoshi Eletu case. It is my contention regarding this case. One, that Are Afe Babalola corrupted the Supreme Court to procure a fraudulent judgment in the service of his clients. Two, that the law firm of S.B. Joseph and Co. procured a warrant to execute the said judgment by doctoring the original judgment of the Supreme Court. Three, that Atilade O. Justice at the time and the administrative judge of Lagos Judicial Division unlawfully issued a warrant of execution based on the doctored judgment and without the enrolled order of the Supreme Court. Four, that Atilade J. quashed the fraudulently obtained warrant following an application of counsel in protest against same. Five, that Are Afe Babalola, Oludaramola, Olufaro, and the law offices of the Afe Babalola and Co. Emmanuel Chambers compromised the Supreme Court and the remaining semblance of integrity it might have had when they went back to the Supreme Court and got that court to swim in the sewer of corruption and shameful self-abnegation. Six, that Lawal Pedro San, at the material time, the Solicitor General of Lagos State, corrupted himself, abandoned the interest of the state, its citizens, and any pretense to decency, and became the undisclosed attorney to the Eletu family, thus betraying the public trust. Seven, that Afe Babalola libeled me, and the fact of the libel became known to me in his suit against Lawal Pedro San. 8, that I sued Afe Babalola San for libel, and that he leveraged his influence in the judiciary to deny me justice. 9, that Oyekon Abdullahi J. was the instrument of injustice employed to deny me my day in court. 10, that the Nigerian justice system is criminal and complicit and can therefore not uphold the tenet of true justice, nor the dispense thereof to which it is sworn. The story I intend to tell is wrapped around the above facts and have been carefully espoused to highlight only the facts of the matter. After all, of what use is a lawyer without his facts? And here is the preface. I do not know Justice Ariwola as a person, but I am familiar with his work, having been connected with a case he was involved with. And I can say this as a fact, that I don't expect anything substantial to change in relation to justice delivery, because one of the most violent injustices I've ever seen coming out of that Supreme Court came from a panel on which this particular justice sat twice. The case is Badamasi Eletu versus Akinloye. It is one of the most unusual cases I've ever seen in my life, where the Supreme Court turned itself into a mathematician, subtracting and dividing land and deciding on a property that was not before it. So, when it comes to expecting any justice from that court, I don't expect any. Not because of his person, and already regarding his person. As far as I'm concerned, it is either he is incompetent or he is corrupt. It is one or the other. These are grievous allegations, and I am making them carefully. For when it comes to the issue of justice delivery, I do not believe that anything will change. When you begin to deal with technicalities of the rules of courts, administration of courts, well, maybe he might perform some magic in that regard, but insofar as it relates to delivery of justice, I expect nothing. I was a guest on the Arise TV morning show. I was out of the country in the United States. My friend and brother, Guru, had just picked me up from the airport in Washington, D.C. on my arrival on holiday from Nigeria. When I received the call from TV station, and I had to wake in the middle of the American night, still largely suffering from my jet lag, to take the interview by Zoom. We had covered a range of issues and were nearing the end of the interview session when Dr. Ruben Abati asked what he must have believed to be an innocuous question. But he was asking my opinion on the recent appointment of the then acting CJN, Chief Justice of Nigeria, Kayode Ariwola. The above was my response. The interview was conducted on the 20th day of June 2022. The proceeding is necessary in order to save my would-be interlocutors, persecutors, and beneficiaries of this decadent system and its defenders the time and energy that they might waste on my attempt at ad hominem attacks. My position precedes my involvement with the Peter Obi presidential campaign, and my exertions are completely non-partisan. Furthermore, this manuscript has been ready for publication since May 2023, but I have deliberately waited until after the Supreme Court's decision on the presidential election matters had been announced before deciding to publish. This I have done in order to ensure that the question of partisanship is not allowed to become a distraction for those interested in the pursuit of truth and justice in Nigeria. I wanted to ensure that this effort is not tainted with accusation of partisanship. I need us to be focused on the issue, the utter uselessness and unfitness for purpose of the Nigerian judiciary. I went to the law school with a Christian gentleman. He went to university in the UK. He was older than me, but we were cordial with each other, and I had a lot of respect for him. His wife and children were still in England when he was one of the first set of students admitted into the wilderness. That was the Nigerian law school. Buhari. His story in it is his to tell, if he cares to tell it, but I am obliged to share the part that is relevant to my story. We shall name him Titus, but that is not his name. Titus was the model student. He was in all the classes, tutorials, and dinners. It was always black and white, a penguin. The MIB have nothing on Titus. And what's more, he was one of the leaders of his fellowship. Titus aced his exams, like particularly everyone in that exceptional foundation class at the Buhari Law School, and probably still holding the record for the highest percentage of passes. But the Council of Legal Education decided it would not be calling this model lawyer to the bar. It was measured by these upright men and women, and they had determined that he had fallen short of their lofty standards. In fulfilling the form required of every student applying to be admitted into the bar, Titus had disclosed that he was convicted on a misdemeanor, one that had since been expunged from his record by operations of law and a fluxion of time. He, being a Christian and a born-again leader of fellowship, a man of faith, integrity, and good conscience, he made full disclosure of a past he had no obligation to reveal, and it was shown exactly how un-Nigerian he had become and was deemed unfit for the Nigerian bar. I don't know if he has been admitted to the bar today, but the Nigerian legal system is poorer by the hypocrisy of his non-admittance, and he is owed a debt of apologies by all concerned with his fate. I am under no illusion about what has befallen our country and its judiciary, but it is the duty of those who are blessed to be able to speak the truth to speak. The Nigerian judiciary is the exact same as the Nigerian police, customs, the immigration, and every other part of our portrayed society. Àìsàn tó ń ṣe ẹgbẹ̀fà náà ló ń ṣe ọ̀ọ́dúnrún. Àìsàn tó ń ṣe abọ́yadé gbogbo lọ́ya ni ó ń ṣe. What afflicts one is evidence of what is common to all. There are no parts of the Nigerian state that have been spared by the evil that has overtaken our land. I have set out to show you the extent of the decadence, corruption, and impunity that have overtaken our country. And in doing this, I have ensured that I am fastidious about telling the truth. I have absolutely no problem with meeting every single writ that anyone might care to issue for libel, and the evidence of the truth that I have told are largely in the court's record. The last hope of the common man in Nigeria is lost, and the CJN might as well prescribe the removal of the colonial wig and decree that every judge should adorn the Tinubu cap in his stead. The Nigerian judiciary is the foundation of the impunity that has overtaken our country, and it must be redeemed before we might be able to regain our liberties first as human beings, and then as citizens. By some miracle that is uniquely Nigerian, we have managed to evolve a criminal justice system. The tragedy, however, is that it is the system itself that is criminal, and the ones who should be citizens have become victims in the vice grips of a three-pronged system. The executive is helmed by a man who is everything that should be nowhere near the office, but then he is the sum of the part of each and every one of his predecessors. The legislative branch is largely peopled by the most myopic collection of humanity, persons unyoked to vision, sybaritic cretins, focused on consumptions, and they are completely uninterested in the plight of the people. The Trinity is completed by the judiciary, and it is of the judiciary that I write in this book. The truth has become transactional in our country, and in its transactional form has equally assumed the toga of subjectivity, where every single truth has to pass through the test of subjectivity before it might be accepted as truth. But I am comforted by the knowledge that the truth is the only weapon that is capable of slaying Nigerian monster. In weaving this narrative, I have maintained a strict fidelity to the truth. I challenged each and every one of the men and women who have been named to point out any lies that I might have told once they are done with the ad hominem attacks. If Nigeria must be saved, it will be because we found the grace to face the truth of the many lies that we have told ourselves and that we have collectively promoted. What we have managed to build with our lies is a judiciary that is very much us. It is built in the image of the Nigerian state. It mirrors our police, customs, and other institutions of our failing state. Our judiciary is completely Nigerian. There is nothing of the bastard in the men and women peopling our criminal justice system, but it is the system itself that is criminal. And it is the practitioners from the registrars to we, the lawyers and the judges that are generally criminal. The Nigerian judiciary is not the hope of the common man, but is in truth completely hopeless and unfit for purpose. Pretty much a mirror of everything Nigeria. This is the foreword, put it that way. Sorry, the preface. Now we have the introduction. We haven't started the book yet, though. So you can see why Tifnumbu and his gang are involved now. Because this book also pointed to their roles and beneficiary in this rot, from this rot called Nigeria judicial system. A drug dealer, a former drug baron, heroin trafficker is the president of Nigeria. And Nigerian judiciary, Nigerian senior advocate of nuisance, all these lawyers, they defended the criminal, a certificate forger, and he is today the president of Nigeria. That tells you all you need to know about the Nigerian judiciary. But let's continue. Introduction to this book. Some years back, I wrote an essay titled, "I Do Not Write for You." I dealt with the issue of writing for a people who have demonstrated an inability to understand the concept of public accountability and who have proven themselves incapable of connecting the dots or understanding cause and effect. Nothing has changed since I wrote that piece, and I find myself saying to my readers, even now, I do not write for you. The Nigerian legal system is completely lost. It is not capable of self-regulating itself, and it is beyond redemption in the absence of a systemic regeneration that is founded on a moral revolution within the Nigerian state itself. The judiciary is reflective of the society in which it exists. And to be fair to the judiciary and its functionaries, they are representative of what values the society holds dear. The Nigerian state is feudal state. It has no room for the niceties of citizenship, the rule of law, nor democracy. The state requires that some people be above the law, whilst others must be kept underfoot. In the complete absence of the rule of law, a most perverse system has emerged that mimics the substance, but which is shorn of it. The police have no power to enforce the laws, and they, in the absence of that, enforce the reign of impunity. The courts are obliged to pretend that the law rules, but in reality, they have little choice but to interpret the laws with subjective content. The system of administration of impunity has assured that members of the ruining class, you call them ruining class, are rarely ever held to account for their serious crimes against the victims of their misrule. But the victims are never spared the harshness of the laws devoid of equity. The law enforcement agencies, from the police to the multiple paramilitary forces, are clear about the persons to whom the laws may apply, and these are almost always the underclass and victims of the Nigerian state. The affluent and connected are rarely ever apprehended for their crimes, but the poor are routinely victimized. When the rich are taken before the courts, it is almost always because of some internecine warfare within the ranks of the privileged. And when this happens, they have demonstrated an uncanny ability to find the capacity to exploit multiple ways of escaping the consequences of their actions. Corruption has become a special class of offenses that is increasingly the exclusive preserve of the rich and powerful. And almost all cases in this class ends with some plea bargain and or the filing of nolle prosequis, no prosecution. The poor, on the other hand, is never able to catch a break. There are persons in our prisons that have absolutely no business with being there. And it has become the standard fare that justice is for the rich, whilst judgment are often for the poor. In 2017, I was hauled before Dada J of the Ikeja Division of the Lagos State High Court by the EFCC. My offense? I had stood surety for a member of my then church, and the ingrates absconded. The EFCC, which had turned itself into a debt collection agency, proceeded against me with extreme prejudice. It had no interest whatsoever in the facts and or circumstances of the case, but was completely focused on ensuring that I paid the debt owed by the woman and her company to the bank. I witnessed the case unfold as I was also being tried. The EFCC was prosecuting a young woman and a co-accused. The woman had been apprehended at the British High Commission. She had presented forged documents in pursuit of her visa application, and her co-accused person, an aspiring travel agent, was the procurement officer responsible for the forged documents. By some orchestration, the case will usually be heard on the same day as mine. It was always heard before my case would be heard. The young woman had lost hope in Nigeria and was looking to flee from the country of her birth by any means necessary. The travel agent was just looking to earn a living by any means possible. The two were eventually found guilty and sentenced to prison term by the ever-diligent Dada, the prosecutorial judge who sits atop the Special Offense Court in Ikeja, Special Offenses Court in Ikeja. Sentence was imposed in their case the very same day. When Kemi Adeosun, the then finance minister, was paying the price for the palace intrigue that saw her leave her office on account of her having forged an NYSC exemption certificate. Same crime, different outcomes. The Nigerian judiciary has no justice to dispense and has evolved to become a part of the putrefaction that has overtaken the land. I do not write this book for you, but I write to inform the coming generations that not all of us are complicit in the mess that has been made of our country, for which we are all paying a hefty price. Brethren, we shall now go into the chapters of this book. And that's going to be the first chapter. Chapter 1. The truth, or should I say truth, dies in darkness. Nigeria is a very dark country, and we are in a particularly dark place as a nation. The Nigerian state is maintained by an inequitable system that is scaffolded by injustice, and the system is allergic to the supremacy of the law. The long years of military dictatorship have destroyed the appointive system of filing judicial positions refined in the early days of our independence, and the judges appointed by the soldiers and prompted by the inheritors have reached the heights of judicial offices. The Nigerian judiciary has since become completely immersed in the purulent practices of Nigeria and has become